Hello, everyone. Welcome to the LAOT podcast. I'm Arnav Mathur. I'm a fourth year law student at Nalsar University of Law and an editor at LAOT. It's a pleasure to have Dr. Gautam Bhatia with us today. He is a Delhi based advocate and a constitutional law scholar. He holds degrees from various prestigious universities like NLSIU, Oxford, and Yale. He's authored multiple books, including non-fiction and fiction books. And most recently, he published a book titled The Indian Constitution, A Conversation with Power. This book tries to bring in new lens to analyze the Indian Constitution. The Indian Constitution is looked at as a document that creates, shapes, channels, and constrains power. Dr. Bhatia asks certain fundamental questions about the structures and institutions that the Constitution creates and the web of powers that it establishes. Thank you for joining us, Dr. Bhatia. It's a pleasure to have you.
Yeah, thank you for having me. It's lovely to be here.
Now, in this book, you diagnose the Constitution through its power map, specifically looking at the time period between 2019 to 2024 as a window to analyze its deeper structure. Now, my preliminary question is why? Why this project? Why take up power as the master lens to analyze the Constitution? And why now? What did you think was a blind spot in the Indian scholarship and public debate that needed to be urgently addressed?
I think just to clarify at the outset, 2019 to 2024 is not really the lens through which the book examines the Constitution. It's something I begin with in the introductory part of the book because it's something in recent memory. And so many of the examples will immediately make sense. But the actual argument of the book is really not linked to the last 5 years. In fact, I want to dispel one of the commonly articulated notions that the last 5 or the last 10 or 11 years, as the case may be, mark some kind of a rupture in the way that politics is conducted within the constitutional scheme. I think that's not the correct way of looking at things. So in that way, there are just some examples from the last 5 years that at various points illustrate the major argument of the book. But once you get into the actual chapters, the judgments I look at can range from 1960 to 2024. It just depends on which of them actually makes sense in the context of the argument. Now, as far as why this approach and why now, so the genesis of the book or the idea of the book, the origins lie in my work on the constitutional challenge to Article 370 as abrogation by the Parliament on August 5th, 2019. I was shortly after engaged on the brief, and when I examined the various legal moves that had been made, they struck me as being very evidently contrary to the Constitution. Now, whatever the court may hold is a different matter, but it seemed to me that objectively they are very evidently unconstitutional. But when I began to read more, because we don't normally read Article 370 jurisprudence as part of our normal work as either law students or law scholars or lawyers, I found a much more complicated picture emerged, and moves similar to the move that had been made now had been made before and had been endorsed by the Supreme Court in cases prior to this case. So it became a lot more murky. And it seemed to me that at the time, of course, this is also around the time when you had the CAA and RCA protests and the farmers' movement, a lot of other things that implicated the Constitution. And I felt that a large part of the discourse, which was that the Constitution is a wonderful document which is being let down by bad judges, or judges who are either unable or unwilling to interpret it in a proper way, I found that discourse to be inadequate in really understanding what's going on. So I began to investigate a little deeper, and here I found the analysis of power to be particularly helpful. It's something that is perhaps a little new in the Indian context, but it has a long lineage, and specifically in examining Latin American constitutional history, it is a framework that has been deployed by the constitutional scholar Roberto Gagrela. And
Correct.
so I found his approach quite helpful in, well, understanding first of all what was happening in the Article 370 case, including and up to the court's actual judgment, which came out when the book was almost done, and I had to, add a section afterwards explaining the judgment, but it fit perfectly well with the argument. And also, it explained a lot of other things going on that seem to be disconnected from each other, seem to be isolated, but the lens of power and what I call the Constitution's centralizing drift seem to have explanatory power in really explaining a lot of what was happening, both in terms of political actions as well as the Supreme Court and the High Court's responses to these actions. So that's why I found this approach to be helpful and useful in understanding the Indian Constitution.
Perfect. Thank you so much. I think the most important point is that even though the the starting point of your inquiry might be through the 2019 to 2024, but those are just examples, and the book, the argument that is being developed has a broader scope. What's also interesting to me is to understand the connect of this book with your earlier scholarship, which is the Transformative Constitution. There you had foregrounded the document as a vehicle for social change and rights expansion. Now you analyze it through the lens of power. What I want to understand is that how are these two frameworks linked to each other, whether or not there is any linkage, are they distinct from each other, or are they just are they just different faces of the same constitutional story?
Well, I think experience makes you more pessimistic in life, and I think you can see a certain progression from 2019 to 2024, which, I mean, I'm half joking, but I think that in 2019 I was certainly much more optimistic about the promise of constitutionalism. Even in the 2019 book, The Transformative Constitution,
Yeah.
I do make it clear that the judgments I consider are not all, and in fact, quite a few of them are not actually good law. Some of them have been overturned, some of them are no longer followed, and what I call that jurisprudence in 2019 is a contrapuntal canon. So, it's basically, it's the canon of case law that, were it to be followed, it could fulfill the Constitution's transformative promise. But as of now, even that is really, it's up for debate. But the central argument of the book in 2019 was that the Constitution is a transformative constitution, and transformative constitutionalism is something that is possible and worth striving for. Now, at that point of time, much like a lot of Indian constitutional scholarship, I was focused on the questions of rights. And that's why all of the chapters in the transformative constitution concern rights. Article 14, 19, 15, clause 2, 23, 21, and so on. And over the years, I've come to believe that is a fundamentally inadequate way of looking at constitutionalism, because it tends to really decontextualize rights, depoliticize, where the power actually lies within a constitution, and doesn't take into account that understanding rights or trying to make a rights-based argument without taking into account the political economy within which those rights are embedded will lead you to all kinds of wrong and perhaps over-optimistic conclusions. So in that way, 2024, or this book, is perhaps a bit of a corrective to 2019. And the argument in this book actually is that, well, I don't have a conclusion in this book. I end with a question, but the question is that whether a constitution that is fundamentally, both in its design and the way it's been interpreted over the years, centralizing, whether you can ever really hope to have meaningful emancipation or equality within a constitution that is or tends to, in this manner, centralize power. So that is the question I leave readers with at the end of this book.
Understood. It's interesting to see the development from your previous transformative constitution to this book, and how power then becomes a more important and a more realistic tool to understand the constitution and its workings. Now, one of the central arguments that you make relates to something called the centralizing drift. And I'd like to quote how you define it. It says, you say that in the 7 decades of the working of the Constitution, there has been a gradual drift towards entrenching a first set of characteristics: unitary, concentrated, representative, electoral, homogeneous, and statist power on one side, at the cost of federal, distributed, direct, guarantor, plural, and individual power. This really seems to be the central thesis of the book. Could you talk us through what this centralizing drift looks like? What does it mean? What does it look like in practice? And perhaps you could identify one example of a centralizing drift that we can clearly see, not just in the adjudication or the inflection points that you mentioned, but also in the text itself.
Well, I mean, I can give you two examples, one an old one, a new one, just to sort of, so the point is clear. The old one is a case which I discussed in the federalism chapter, State of West Bengal versus Union of India, where the Union of India tries to take over certain coal-bearing lands in the state of West Bengal. And the question is that entry 42 of list 3 of 7th schedule, which vests competence in terms of lawmaking to both the union and the states, is at that time, it was subsequently amended, used the language acquisition or requisition of property. So the Union of India argues that it is invoking entry 42 of list 3, and that entry is what gives it the competence to pass this law that then allows it to acquire these coal-bearing areas. West Bengal argues that it is a federal polity, and federalism means that in their individual domains, both the states and the union are sovereign, and if sovereignty means anything, it means that one sovereign cannot acquire the property of another sovereign without their consent. And so they say that you must read entry 42 as having the words acquisition or requisition of property except for state property. The Supreme Court, by a 5-1 majority, rejects this argument, and they say that look at the entire scheme of federalism in this constitution. It is clearly skewed towards the union, and if Parliament has the power to create, destroy, or alter the boundaries of states, it seems absurd that it does not have the power to acquire state property. So you can see how constitutional design, which already creates a skew in terms of powers towards the center vis-a-vis the states, is then invoked by the court to further entrench that power. In effect, the court argues that where you have a constitutional silence or a constitutional ambiguity, the interpretation has to be in favor of central power over state power. So that's one example of how design and the Supreme Court's interpretation intersect. Now, I argue in the book that that wasn't the only possible reading. You could have a different reading, but that's not the reading the court adopts. The dissent does. The more recent example is, of course, the Article 370 case, where actually and this is actually almost the court going against the constitutional text, but that's a different debate, where the court basically upholds the abrogation of Article 370, and the overarching logic of the court is that the ultimate goal of this article is the integration of Jammu and Kashmir with the rest of India. But of course, the word integration is not a self-interpreting word. It has to be given certain meaning. And the court says that the word integration actually means a homogeneous nation state where every state has a similar relationship with the union. So the court reads homogeneity as uniformity, the court reads integration as requiring homogeneity and uniformity, and the court is suspicious of pluralism, constitutional pluralism, where in a country as diverse as India, with its ethnic, political, linguistic, and cultural diversity, the constitutional arrangements should reflect that diversity is basically what constitutional pluralism requires. The court is very suspicious of any kind of pluralism, and therefore it actually twists the language of the provision in order to justify that outcome. But the point also is that Article 370 is one of the most ambiguously drafted provisions in the Constitution. And its origins actually lie in a political compromise. So Article 370 did not come into the Constitution as some kind of a principled commitment to regional autonomy, a principled commitment to pluralism. It came into being as a pure political compromise designed to keep the strategically important state of Jammu and Kashmir within the Union of India. And that history, which then reflects in the wording, then allows the court to really discard any arguments for founding the autonomy of Jammu and Kashmir on a constitutional principle, and therefore they're easily able to then almost ignore words in the text to justify the integrative process that ends with the abrogation. So I think these are two examples where you see the intersection of constitutional text and design and judicial interpretation that basically lead to this centralizing drift. And West Bengal was a 62 case, 370 is 2023, so that's like basically you're looking at the beginning and the end of the constitutional project. By the end, of course, I mean the most recent examples.
Understood. I think it's interesting that we can find examples from old case laws such as the state of West Bengal and more recent ones as well.
Yeah.
But if I were to push the question further, to what extent do you think that this is a constitutional choice, or
Yeah.
to what extent is it a product of India's political history, where historically we've had strong central governments? Because one could argue that the Constitution was deliberately framed as a centralizing document from the outset. Then how does your idea of centralizing drift then counteract with this? Because this is again what goes counter to Justice Subbarao's dissent in State of West Bengal and what the majority held, is that you look at the initial understanding of the Constitution. So how would you counter that claim?
So what I say in the book is that the Constitution is a terrain of contestation, right? So if you look at the constitutional text and the history of its framing, a lot of it actually is the result of compromise. The assembly members in the Constitutional Assembly could not agree on a range of things. Now, unfortunately, depending on where you stand, it so happened that Nehru, Ambedkar, and Patel were all agreed on centralization for different reasons, but not to put too fine a point on it. But because of really this compromise and this conflictual founding of the Constitution, on the one hand you have centralizing provisions, but then you also have, other kinds of provisions that, counteract or act in the opposite directions. So in that way, as with any text, it is an open textured, document, and any open textured document is subject to interpretation. So in that way, if you want to, as a court or as an individual or as anyone, to interpret the Constitution in a way that counteracts the centralizing drift, you can. And sometimes it has been done. Now the problem, though, which I argue in the book, is that even though there's a terrain of contestation, even though you have counteracting impulses, the dominant impulse is centralization, and so that actually makes it harder to counteract. And I'll give you an example, right? So, election commission's independence. So, Article 324, right? So it says that the chief election commissioner shall be appointed, and I'm paraphrasing, shall be appointed through a law made by Parliament, and until such time as Parliament makes a law, the appointment is by the President, which basically means by the government, say in advice. And so, in the original constitutional text, and the Constitution, actually the original Constitution, is a deeply executive trusting document, and we can discuss the reasons for that later on if you want to. But it is a deeply, deeply executive trusting document. And you can see that in a provision like this, where a body that is literally tasked with refereeing elections, where the executive's party will be a candidate, is actually being appointed by the executive. Now, the framers evidently believed that this is a power that would not be misused by whoever was in power, and that has clearly not been borne out. And so, in the Anup Baranwal case, the Supreme Court basically says that, well, if you really go deeply into the debates, you will find that the intention was to for the commissioners to be independent. Parliament was meant to pass a law guaranteeing that. Parliament has not done that. Therefore, we as the court are going to set this interim arrangement up, which is actually a really terrible arrangement, even interim or otherwise, of the Chief Justice, Prime Minister, and LOP as the appointments committee. Now, that is a complete judicial invention, and because it's an invention, it makes it particularly fragile and pretty easy to just sort of do away with. So what does Parliament do? Parliament enacts the law, which it is authorized to do under Article 324, and basically makes the Election Commission formally subservient to the executive by having a 2-1 majority. Now, of course, now you file a challenge and say, okay, this is unconstitutional, because the intention always was to keep it independent, but where in the Constitution is it said that the Election Commission has to be independent? And compare this with, for example, South African Constitution, Kenyan Constitution. They clearly have these specific chapters in the Constitution that deal with institutions like the Election Commission and categorically state that their independence is something that is constitutionally entrenched, right? And we don't have that. And again, there are reasons for that, historical and so on, we can go into that. But basically, the thing is that while any text is open textured and can be contested, there are directions in which the text points you to, and as does this history. And it is much easier as an interpreter to really flow with the direction of the text than flow against it, right? So you can, as an Anup Baranwal, you can counteract the text impulses, but it is obviously much harder than just saying, just going with it. And I think that's what at least partly explains, along with what I call constitutional common sense, that's what partly explains why such a large part of the court's jurisprudence over the years has always, in these high-stakes cases, opted for the more centralizing interpretation of the Constitution than its sort of opposite.
Right. Thank you so much. I've got two strands of understandings from this answer. One is that the Constitution is an open textured document with different visions and different contestations, and that the interpretation for an interpreter would always be easier to go with the grain. Even though there are different sets of impulses, there would be something that is always favored more. And I'd like to interrogate the first part of your answer in depth. Now, there's a very evocative phrase that you use in the book, which is called Franken-Constitution.
Yeah.
It is a constitutional order where individually seen, the provisions seem to be reasonable.
Yeah.
The moment you stitch them together, you end up creating a monster.
Yeah.
Could you just explain to the listeners what this idea of Franken-Constitution is and what does it look like?
Yeah, so the term is borrowed from Franken-State, which is a term that Kim Lane Shepperly coined, and she was referring to the Weimar Constitution, and basically how a provision innocuous in its own right, when combined with other provisions, can really create a monster like Frankenstein's monster. And she talks about the dissolution of the parliament in the Weimar Constitution and all of that. Now here, the example, I think one really good example is the Maharashtra political crisis, right? So it begins with, of course, the defections of these various MPs. Well, they say they're not defecting, they say they're the real political party. And now there's a whole schedule of the Constitution that's meant to prevent this kind of thing. But the way that you administer that schedule really depends upon two entities, two officers, the Speaker of the House and the Governor, because the Speaker is the entity that will adjudicate defection petitions, and the Governor is the entity that will call for a floor test or a sitting of the House. Now, both of these entities are not independent. The Governor is a nominee of the centre, and the Speaker is a nominee of the ruling party, whichever that is. Now, in this case, the Maharashtra case, the Speaker's role is like there's more complexity, which we need not go into because that's a whole other thing of the Deputy Speaker. There's a whole different, very specific political context there. And so the Governor plays that role of calling for a floor test, and knowing that a certain kind of majority is there in the House. Along with that, of course, you have and this is really within the rights chapter, you have laws like the PMLA that basically ensure that you can, as and under the Enforcement Directorate, the ED, which is a body completely under the control of the center, you can basically put people in custody with very little chance of bail for a good amount of time, and we have seen that happen. We've also seen that what the ED has been used to do has been to go after opposition politicians. This is an objective fact, right? And so you have this sort of lethal combination there where you have like weak rights protections that enable a certain kind of intimidation and blackmail of opposition politicians, mixed with anti-defection that is dysfunctional, mixed with like the governor's power of calling for a floor test, calling for the assembly, and each of these you might say independently, you may give some justification for that you need X or Y, but when you combine them together, you find essentially that it becomes very, very easy for a central government, whichever the government is. It's not about a specific government. It's just that our experiences have been with this government. It is very easy for a central government to use its control over investigative agencies, to use its control over the governor, and to deploy the jurisprudence of the Court on Rights, which is a very weak jurisprudence, to effectively engage in regime change in the states. And we've seen that happen in multiple states now, last 5 years. Again, just to clarify, this is not new. The very, very first instance of regime change was in Tamil Nadu in 1952, when the Congress governor Rajagopalachari again used the governor's powers to topple the left-led coalition and bring the Congress government in. So but the point is that these are tools and weapons that are in the Constitution and have been there in the Constitution from the beginning, and this is the constitutional design. And so I think like the important thing is, and as a point I want to make here, is that this whole debate goes on that the present ruling dispensation wants to change the Constitution. They want to do away with it, and therefore all the constitutional defenders must rally around and defend the Constitution. I think that just so fundamentally misses the point. And it misses the point because the question that you fail to ask is that why has every single centralizing regime in Indian history, and by centralizing regime I refer to three: Nehru's regime, Indira Gandhi's regime, and Modi's regime. And of course they did it in different ways, but they were all deeply centralizing regimes. They have all been comfortable with the Constitution, and they have all used constitutional mechanisms to bring about what they want to achieve. So Nehru, of course, was amending the Constitution. Indira Gandhi was suspending the Constitution, and now the present regime, you have, what I said, this sort of combination of various sort of mechanisms. But each of these regimes has always invoked constitutional processes to accomplish what they're doing, and they've been successful. So it's not like Pakistan, where you have army coups, where you get constitutions replaced and new constitutions brought in. It's not like a country, not just Pakistan, like anywhere else. It's not a country where to get what you want, you must sort of remove the constitution because the constitution is actually a barrier. This is a case where every centralizing regime has used constitutional processes to get its way. And I think that's the question then we should be asking, why has it been so easy? And what that says about the Constitution and not about a particular regime.
Right. That's very interesting. I think from the example that you took about the Maharashtra's episode, we can see how different strands, anti-defection law, governor's powers, prosecutorial leverage under the PMLA Act, all of them come together to produce a constitutional order that is more than the sum of its parts. So it's something added on, which then is to be understood as a centralizing drift. And the other interesting point is that all the centralizing regimes that we've had up until now always use and invoke the Constitution in some sense or the other. So then my question then becomes, from a specific example of Maharashtra, to just broaden it, to understand what does this idea of Franken-Constitution and centralizing drift tell us about how we should study the constitutional design. Should we be less focused about isolated provisions? Should we look at more of their interactions? And if the constitution itself is this favoring to has a centralizing drift, what can scholarship contribute to? What can the court do in these situations?
Well, I mean, I think the first thing is that I don't think that, so the book, of course, is something that is focused on courts because it's an illustration of the way courts have acted and have sort of contributed to the centralizing drift. But I don't think the conversation should be about courts because I don't think ultimately the courts are in any way, meaningful actors in counteracting a centralizing drift. And I think that the evidence for that has been abundantly clear over the last 75 years. And like I said, there's almost a constitutional common sense about the fact that centralization is the way we have to go. And you see this again in judgments as far back in 1960s and still continuing. So I don't think that the courts are really, relevant actors in this conversation. And I think you have to also look at compositions of the judges, like, where they come from. I think it's like, it's quite, it's sort of idealistic to hope that judges will be engaged in counteracting centralizing drift, because I think that their own positionality makes centralization a much more attractive proposition to them than the opposite. So with that said, I think so again, I mean, I feel that the argument in the book is that, as long as you have this kind of a constitution with these kinds of provisions, it's very hard to really counteract that. Now, can popular constitutionalism, or what some people call insurgent constitutionalism, can that in some way play a part? I don't know, because I think you haven't seen it happen yet. We did see, I think, interestingly, during the CAA NRC protests, we saw the invocation of Article 14, by the protesters. And I think for me that's really, really interesting, because as a constitutional lawyer, Article 14 is a parchment barrier. It's one of the most deferential standards in constitutional law, and it is very unlikely that you can make a successful Article 14 argument in a court of law against the CAA NRC. But nonetheless, the protesters were giving it a much more capacious and a much more broad and generous meaning. Now, the problem, of course, is that ultimately you can give whatever meaning you want to the Constitution. There is only one institution that has the coercive power at its back to make its interpretation actually the interpretation that can then be backed up by state force, and that's the court. So in that way, I think there are limits to what insurgent or popular constitutionalism can achieve. Of course, in the long run, no court can really afford to be too far removed from what it feels public opinion is. Of course, like, it can shift things, but I think that that's a very, very difficult thing to rely on. And I think also, there's a great paper by Kailash Srinivasan on the legal form blog, which was published soon after the CNRC protests. Relying on the language of rights itself, has its limits. And beyond a point, if you have a popular movement and your claims are on behalf of a movement of people, then the language of rights often becomes both depoliticized and constraining. So I think there's also just, there's a question to be asked whether these mechanisms that the Constitution sets up are themselves, ultimately going to constrain any movement towards, emancipation or equality, and that therefore any such movement has to be conducted not contra the Constitution, but outside of that framework is a question that's worth considering.
All right. So there are two things to note here from what you've mentioned. First is the limits to what the courts can achieve in terms of the incentives that they actually have to go against the grain and to promote an alternative view. And the other thing also to note is the limits of insurgent constitutionalism and the limits to when popular activists invoke the constitutional language. There also you need to understand that there are certain limitations within it. Now, a related point that you mention in your book is, and you've mentioned previously as well, is something called the constitutional common sense. This relates to a set of assumptions, beliefs, and ideas about how the Indian constitution organizes, does organize power, and should organize power. So, both of them. And this is also something that is inarticulate. It's a premise that is not that is widely shared, but it's also internalized. So, therefore, to understand it, you need to literally excavate it. Could you first unpack the most consequential constitutional common sense that is present today for us?
Yeah, so constitutional common sense is not one thing, it's a range of unspoken beliefs and convictions. And much like common sense, you can't normally reduce it to one thing. And, in the Indian context, I think there is a constitutional common sense towards centralization. And when the way it plays out, I'll give you a tangible example. And this is again drawn from the Article 370 case, because I think that case really reveals a lot of these things in a way other cases perhaps don't. Now, in the Article 370 case, one issue was that there were two constitutions: the Constitution of India and the Constitution of Jammu and Kashmir. And one key issue in the case was the relationship between these two constitutions. Now, the idea that in a federal polity, you can have two constitutions, a constitution of the federation and one of the state, and that there is no hierarchy between these two constitutions, but that they are supreme and sovereign in their respective spheres, is something that is very mainstream in both federal theory and federal practice. Many countries have this arrangement. Where, of course, yes, in terms of matters concerning the federation, the federal constitution is what prevails, whereas in domains concerning the state constitution will prevail. And so that's something that is completely normal. In this case, it was an argument that was impossible to make because you just could not argue that the two constitutions were occupying a position of complementarity. There was this ironclad assumption that the Indian constitution is supreme and there's a hierarchy between the two. On many occasions, the Chief Justice, then Justice Chandrachud, CJI Chandrachud, would keep saying, "Oh yeah, but the Indian Constitution is supreme." He would not provide any evidence for this, historical, textual, structural, or otherwise. This was just an assertion that foreclosed any possible argument to the contrary. So this is an example of constitutional common sense. That if you ask someone, okay, why, explain why these two constitutions cannot be actually complementary, you won't actually get a reason grounded in like the law or the history or the constitutional scheme. It'll just literally be an assertion. And that's an example of constitutional common sense, certain idea of the kind of polity India is, where, again, you cannot have constitutional pluralism where, state constitutions in their own domains can prevail. So it's a constitutional common sense. And you find that in other areas. And it's a term that, of course, it's a term that I use in this book, but other scholars have used similar terms. Constitutional culture, Professor Cheryl Saunders in Melbourne, and David Kenny, and there are many scholars who have made the argument that it's not just norms, doctrines, and so on that govern constitutional interpretation, but a lot of it is actually unspoken agreement between the practitioners of constitutional law about what kinds of arguments can and cannot be made, which you will not find written down anywhere.
Right. That's interesting. You also mentioned the 370 case. So my question is that what can you do about the constitutional common sense? Say you're arguing in front of the court where you know that this is something that firstly you have to recognize that this is a constitutional common sense that everyone is running on. But then once you identify it, can there be something done about this constitutional common sense, or do we just have to live with the reality?
Well, unfortunately, the point which you identify it is far too downstream, right? So at this point of time, it exists as the sort of encrusted thing that you can't really shake through reason or through argument. It's just there. Now,
Yeah.
like with any other thing, changing common sense is a generations long process, right? So like to sort of create an alternative counter, again, insurgent common sense, which is actually that the Indian constitution perhaps is more accommodating to decentralization than otherwise thought, is just, I mean, that's the work of generations, right? So it's not going to happen an argument in court. It's too late by then, because at that point you are operating within that field of common sense. You're not operating outside it.
Understood. Uh, Another thing, Dr. Bhatia, about constitutional common sense itself. Now, we in our current vocabulary have this term constitutional morality. Now, it's become quite popular through court judgments and through academia as well. Conceptually speaking, how is constitutional morality different from or similar to constitutional common sense? Are they even related in
No, no, no. There's no connection between these two concepts. I mean, constitutional morality is the term that's used by judges, sometimes by lawyers and by legal scholars, to say, okay, there are a set of principles underlying the Constitution which
yeah.
govern its interpretation. So, for example, federalism as an idea, that you have to have center and states, or secularism or equality. So they're just like normative principles that structure the constitution. But often you will see that these are pegged at level of abstraction where it's not very helpful, right? So they can't really help you in resolving a particular dispute. Of course, they've been used and deployed in cases like Navteej Johar and so on to achieve progressive outcomes. But I think they can be equally well deployed to achieve outcomes you don't like. So I think they operate at level of abstraction that can be put into the service of any kind of concrete conclusion. Also, perhaps why you don't see it being used too often these days. Like it's just not really a big thing these days. Yeah.
Okay, understood. Now, we've discussed about the constitutional centralizing drift. We've discussed about the Franken-Constitution. We've also discussed the constitutional common sense that we have. But all of them, and this is something that you relate to in your book as well, relate to the state's power. And the Constitution is very detailed in how the state's power is to be exercised or constrained. However, the Constitution's largely silent about when it comes to questions relating to private power. Now, this is something that you contrast with Ambedkar's States and Minorities drafts, where he explicitly wanted the Constitution to protect people not just from the state but also from private domination. Now, given the current political situation, if we make a reasonable assumption that a constitutional amendment to introduce such provisions is out of the table, if we run with that assumption, what would you think is the best interpretative route for the Indian courts to address this part of private power? So, how do the courts then manage these questions?
Well, first of all, I don't trust the Indian courts to really make any kind of reasonable judgment on the nuances involved in private inequalities of power. I think, in fact, it would be a disaster for that to happen, because you would have a lot of judgments that would just completely, whether willfully or just by ignorance, misunderstand and misinterpret all of this. And I think you can just to look at it, you can see that a Supreme Court's judgment in Kaushal Kishore, which purports to extend the Part 3 to private parties, is the most incoherent and sloppily reasoned judgment that you will find in the last 5 years, because they just completely fail to grapple with the issues that arise when you do that. So I don't think that the courts even should be getting into this. They should stick to their job, which is giving people bails, which they can't do. But they shouldn't get into stuff that they are not equipped to really deal with. Now, I think the larger issue again is that there is a reason why constitutions predominantly deal with the state, and that is because the constitutions are really premised on something that has been in political economy called the separation of the political and the economic, which is to say that the constitutions that the constitutionalism as a discipline, along with written constitutions, comes into being alongside the development of capitalism as a system of social and economic relations. And one thing that capitalism depends on is separating the economic and the political. So the economic domain is something that is outside the realm of political contestation, and so private power in that sense is depoliticized. And so ultimately, constitutions really are not designed to deal with that, because the moment they start dealing with that, you will find an unraveling of the entire political economy. So, for example, if tomorrow you want a constitution to deal with private economic power, then, for example, let's take a look at what that will do to housing, right? So many of the constitutions have a right to housing. Now, what the courts have done is they've interpreted this right as being a one of progressive realization, which means that I don't have a right to a house right now, but I have a right to the government putting into place some kind of a plan to at some point make housing accessible to me, which is completely unenforceable, right? And so ultimately, if you were to genuinely grapple with private power, you'd have to begin by, for example, decommodifying stuff like housing, food, and so on, which obviously you can't do because that is effectively adopting a whole different economic system. So I think ultimately constitutions are just limited in what they can do in terms of dealing with the various kinds of inequality of private power that are there in our society. Now, of course, they can do something. So they can, for example, outlaw untouchability. They can outlaw forced labor. They can outlaw private discrimination. And that is there in our constitution, and that just requires certain kind of enforcement, which again, we're not having right now.
Understood. I think it's you started off with talking about how there's a distrust of courts handling these sort of issues and the idea of depoliticization of private power. But then my question relates back to Ambedkar's States and Minorities draft. How did he envision a constitution that could deal with both the state's power as well as private power? If you could
Well, he
briefly
began by proposing basically state run, or what he thought was state socialism, but I think what you would actually now look at as state run capitalism, right? So the state controls the sort of commanding heights of the economy, but he wanted to have it constitutionally entrenched. But then at some point he says, no, 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 like we can't do that because every generation must decide its own economic path. That goes out of the window. He also wanted to ensure that the individual worker would be protected from the employer, but he doesn't really clarify what he has in mind. Because if what he has in mind is a minimum wage, or just basic labor right protections, then fine, you have labor law for that. So at best you can have an incremental improvement if you entrench those rights constitutionally, in the sense that they'll be harder to derogate from. But that doesn't really deal with private power. That just mitigates some of. Well, let's just say it makes private power more humane. So it's a bit like you have a bulldozer and destroying a house. You either throw some sand in the grains of sand to sort of make it slow down, or you sort of destroy the bulldozer, right? So just like these kind of things of minimum wage and all is just like throwing a bit of sand in the in the bulldozer's wheels, and perhaps making the destruction more humane, but you're not really dealing with private power in any meaningful way. So I think like he had a very narrow understanding of even if the constitution would deal with that, what it would do. And again, there are reasons for that. I mean, obviously, there are historical reasons why he wanted it to take a certain shape, which are not particularly relevant for the discussion here.
understood. I think it's interesting to compare and contrast the different visions of constitutional making as well. And this brings me to one of the most fascinating parts of the book for me personally. It was the interlude, where you try to recover what you call yesterday's tomorrows. For Nalsar students, we would probably refer to it as the road not taken in
Yeah,
constitutional making. It's in fact an
yeah,
elective for us as
yeah,
well. So
yeah,
you look at different moments like
yeah.
the 1977 post-emergency window and the alternative draft constitutions. Why do you think it's important for us to visit these submerged alternatives
Yeah.
now, and how do they reveal the different parts of the constitutional's power map?
Yeah, so I think that the interesting thing that they reveal is that the arrangement that we have right now is not inevitable. There were alternative paths. In fact, it's very interesting you bring this up because, in fact, today I began reading a book called Underground Asia, which is actually about various revolutionaries in various Asian countries in the 1920s, and how, as part of their national liberation struggles, they were able to imagine a future without nation states. So and Emin Roy is one of those who's also mentioned in my book. And so in that way, constitutions are like really hitched to nation states, and nation states. We can talk about that, but it wasn't always the case. And if you look at some of the radical experiments that were being done in the princely states in the 1920s, you see experiments with a very kind of decentralized, pluralistic kind of governance structure. You see similar experiments in 1947 to 50, M.N. Roy, Gandhian Constitution, a lot of things, and then not so radical. But when Indira Gandhi's emergency was defeated, then there was this brief moment of reckoning with what had happened, because Indira Gandhi had not only used the constitution's centralizing provisions, she had also added more of them. And for the first time, you could see the tangible, actual dangers of that kind of approach to just governance. And then there was, of course, the 44th Amendment, which sought to undo some of the more pernicious effects of Indira Gandhi's centralization. So there actually was, I think, a moment where it was possible to have a national debate on whether this centralizing constitution has served us well, and if now it's now been 25 years, should we still be going with this? But we again missed that bus, because then there was this sort of very partial kind of like rollback, and many of Indira Gandhi's centralizing provisions were left intact, and nothing of the original constitution was really undone. So in that way, I think there were these three moments in history where we could have experimented with other ways of organizing our society. But and just I think excavating them is interesting, because then you see the possibilities. And the chapter itself is borrowed from this book called Yesterday's Tomorrow, which is a book that really deals with many of the historical again points of divergence in sort of the global anti-authoritarian left struggle for freedom and equality, and at points at which actually there could have been a non-Stalinist road, a non-authoritarian road, but each time a choice was made. But the point of showing that there was a choice is to show that yeah, it was something that was contingent, and that I think shows that no human arrangement is permanent, and no human arrangement is natural in that way. Everything is the product of human agency and human choice, of course, subject to the structural constraints that are there at any given time. But human agency always has a part to play in the social arrangements we find ourselves in, and that's sort of the point of that chapter.
Yeah. That's very amazing, because even when I was reading the chapter, these departure points that you pointed out, that if these departure points or these ideas were institutionalized, they would have bent the web away from the centralizing drift now,
Yeah,
and the current reality would be different or not. And this is something that needs to be excavated
yeah,
and theorized about. So this is a really interesting part in the entire context of looking at power as a theme.
yeah.
Now, the last question that I have for you today is, I think, something that you've answered throughout your all of the answers today. I understand that this book is just a starting point for a conversation. It's just a
Mm.
lens to look at the way Constitution organizes power. It's not a blueprint or
Yeah.
a prescriptive book. But the question is more idealistic, in the sense that, can a decentralizing power map exist or be pursued within this text, given the baggage of the precedents that we carry now? Can we do it now? Can we do it in the future? And if your answer is yes, then how do we do it?
Yeah, I think within this text, I don't really answer that question in the book.
Yeah.
I'm quite skeptical. As both in my experience as someone who engages with the Constitution at a theoretical level and also in courts now for a while. I think that I'm quite skeptical. I think that it's like something that is very hard to do, and it's just something I think that constitutionalism itself is really not equipped to, because, as I said, constitutionalism is really comes into birth with the advent of capitalism, and they both need like a nation state, to sort of like organize themselves. And as long as you have that premise, you will always have this kind of centralization going on. So I think that it's quite difficult, and we need to sort of fundamentally rethink our constitutional arrangements and ask ourselves first, well, what kind of a society that we want, and then ask ourselves what kinds of arrangements will govern that society. The first question I think is not can we alter or interpret the constitution to achieve X or Y. I think the first question is to ask ourselves is that what society do we want, and then what kind of institutions will really serve that goal. But again, that latter question is not something that an individual thinker can provide a blueprint for. So that's something that can only happen in the doing of it. And I mean, the same person who recommended to me that yesterday's tomorrow's book also recommended to me this great piece called Forests and Factory, which makes this point. That you can't have a blueprint. It has to come through that sort of conversation, and it has to emerge out of that sort of equal conversation. And so I think like that is really for me the conversation worth having, and not so much how do we interpret the constitution somehow to get more progressive outcomes, because I think we have tried that and it's not worked, and there are reasons why it's not worked. It's not to do just with judges not getting it. I think it's the reasons are deeper and more structural, and I tried to sort of highlight some of those today.
Thank you so much. I think this book and this conversation is very timely and critical interrogation of how the Indian Constitution should be. It's also it also gives you a peek into what the scholarship might be missing and where we should put our focus. So, as a conversation starter, as a lens through which the constitution needs to be viewed, power seems to be one of the most important parts. And of course, we've discussed the various different themes of your books as well. Uh, the centralizing drift, how individual provisions can sometimes create something more bigger, which is the Franken-Constitution, and also how the questions of private power need are not always best be trusted uh, to be delivered and interrogated by the Indian courts. We've also looked at what by far has been the most interesting part about how we have to understand that the constitutional reality that we have today is not inevitable. And that fact also can give us some indication as to how the conversation should move ahead. So, thank you so much, Dr. Bhatia, for coming here, for writing this book, and for discussing this with LAOT. We're always grateful to have you on the podcast.
Thank you, my pleasure.